Hello friends, welcome to polity class. Today let us discuss about Indian judiciary system. So judiciary system consists of all the courts in the country. Among all the courts we have Supreme Court as the highest court. So Supreme Court comes under part 5 of the constitution. Now why are we dealing with constitution when we are reading about Supreme Court is that polity is all about constitution. So in part 5 we have articles 124 to 127. These articles deal with the Supreme Court. So coming to the history of the Supreme Court, Supreme Court is used to be called as Federal Court before independence. Federal Court was established by the Act, Government of India Act 1935, and after independence it is known as to be a Supreme Court on 28 January 1950. So what does this Supreme Court do and what is its function? The main function of the Supreme Court is that it has to act like a watchdog of the Constitution. If anyone tries to break the orders and laws, it punishes them. And the second primary function of the Supreme Court is to protect the fundamental rights of the citizens under Article 13. And the first Chief Justice of India is H.J. Kania. Initially, Supreme Court strength was about 7 judges and 1 Chief Justice of India. Then it increased to 26 and presently it is 31 judges. So this is the history of Supreme Court, and now we shall discuss about the articles. Article 124 deals with the appointment of judges. How do we appoint the judges? Currently, appointment of judges is done by NJAC, National Judicial Appointment Commission. Previously, it was done by Collegium. Now, by 99 Constitutional Amendment Act, we have created NJAC. So, NJAC will see the appointment of the judges. Now, what does NJAC consist of? NJAC consists of 1 CGI, 2 senior judges, followed by CGI, who will be taken after this CGI, and 1 union law minister and 2 eminent persons by select committee. So now what does this select committee consist of is, select committee consists of 1 prime minister, CJI, and 1 opposition party in the Lok Sabha. And what is the criteria for choosing these 2 eminent persons? And among the 2 eminent persons, 1 should be from either be woman or a minority citizen or an SC or ST candidate. So these 6 members would jointly form the NJAC, and accordingly to that judges would be selected. And who is the NJAC convener is Law Secretary of India. Now let us discuss about Article 125. Article 125 deals about qualifications, salaries of judges. So what are the qualifications a judge should have is that he should be a citizen of India and he should work as a judge of High Court for 5 years or as an advocate of High Court for 10 years. And there is no minimum prescribed age for being as judge. And what is the tenure of a judge? A judge can have 60 years of term, or else he can work as a judge until he attains 65 years age. Whichever is earlier, the court would consist that tenure. So coming to the removal procedure, a judge can be removed by proving his misbehavior or guilty. A law can be passed in the Lok Sabha or else Rajya Sabha on either of the houses. For Lok Sabha, at least 100 members approval must be there, and from in Rajya Sabha, 50 members support must be there. If a bill is initiated in the Lok Sabha for removing a judge, a presiding officer permission is to be taken. Even if it's initiated in Rajya Sabha, presiding officer permission should be taken. And this presiding officer will ask a select committee which consists of 3 members, 1 CJI, senior judge of Supreme Court, and 1 Chief Justice of High Court. These 3 members would combinedly give a report and submit it to the Lok Sabha. That report would be presented in either of the house. After getting special majority, President will give removal orders. One important point to note here is that the impeachment of any judge does not stop on resolution of the House. Here impeachment means removal. And this, the removal of any judge does not stop on the dissolution of the house. If the Lok Sabha is dissolved, any other house must take up the impeachment of the judge, or it must continue for the next term of the house. Now Article 126 deals about acting CJI. If the Chief Justice is not there or he is resigned, the next senior most judge in the Supreme Court would act as Chief Justice of India for a temporary period until an actual CJI comes. Article 127 deals about ad hoc judges. Ad hoc judges is when the Supreme Court does not have a full strength to take up its session, then Supreme Court would elect one person as ad hoc judges for a temporary period. Article 128 deals about retired judges. Any retired judge of the Supreme Court can be taken as a judge of the Supreme Court for a temporary period. He also enjoys all the privileges of a judge, and ad hoc judges and retired judges enjoy the privileges of all the judges for a period of 3 years. Article 129 deals about Court of Records. Court of Records is that whatever the Supreme Court has given earlier judges, those judges can be used as references for all the courts of India. Any High Court can use that judgment. Contempt of court. Contempt of court is that Supreme Court has power to punish those persons who violate the law and order. Under this article, it can punish anyone who has violated the laws. Article 130 deals about the seat of Supreme Court. Seat of Supreme Court is that where is the Supreme Court situated. Currently it is at Delhi, but Chief Justice of India can, if he has any idea to change its position, he can change it with the consent of the President. Article 131 deals about original jurisdictions. There are 4 jurisdictions primarily: original jurisdiction, appellate jurisdiction, writ jurisdiction, and advisory jurisdiction. These 4 are the primary functions of the Supreme Court. Original jurisdiction deals about all the cases of general importance and any dispute between the states. This original jurisdiction is very important for the Supreme Court, which deals the cases between the center and state and any disputes between one state and 2 states, or else any disputes between 2 states and the center. Supreme Court would deal with all these disputes. And next is appellate jurisdiction. Appellate jurisdiction has 3 articles within it. Article 132, 133, 134 come under appellate jurisdiction. 132 is about the cases wherein which High Court brings to the Supreme Court about constitutional amendments, or else if any case that violates the constitutions, these cases would be brought by High Court to the Supreme Court. 133 deals about the civil cases. 134 deals about the High Court, which bring to the notice of Supreme Court only in criminal cases. Next, coming to writ jurisdiction. What is actually a writ? Writ is an order. Writ jurisdiction deals mainly with the fundamental rights of citizens. So what are the articles? Article 32 and 139 come under writ jurisdiction. So these are for fundamental rights protection. Next is advisory jurisdiction. So main thing here is that US Constitution does not have advisory jurisdiction, while Indian Constitution has advisory jurisdiction. When anyone asks you the difference about US Constitution and Indian Constitution, major difference is this advisory jurisdiction. It deals about the President seeking the Supreme Court advice on constitutional matters. The Supreme Court gives some advice to the President, and it is not binding on the President. The President can agree or disagree with the Supreme Court's advice. Coming to Article 136, it is special leave petition. This special leave made by any court is granted by the Supreme Court. If High Court wants to take any leave for dealing any criminal case or civil case, it can approach to the Supreme Court. It cannot approach for a leave for some specific cases like armed forces. Article 141 deals with the law declared by the Supreme Court that shall be binding on the all courts. This means that whatever the law is given by the Supreme Court, all the lower courts, that is High Court and Municipal Court, subordinate courts, must listen to the Supreme Court judgments. The judgments given by the Supreme Court not necessarily to be listened by the Supreme Court itself. The Supreme Court again can refer to its previous judgments, can also change its previous judgments. 137 deals with judicial review, which is very important part of the Supreme Court. That is, Supreme Court has powers to review its earlier judgments, and it also deals with constitutional validity of legislative enactments. It can also again refer to the legislative enactments and amend it. 147 deals with the Supreme Court. That is, it tells that Supreme Court is the interpreter of the Constitution. That is, Supreme Court is the ultimate power in interpreting the meaning to the Constitution. So you will be getting direct bits from these articles. You can also get, so what we have referred to until now is that how is Supreme Court established, what is its history, and what are the articles that are dealing with it. There are some famous cases which Supreme Court has held. Those would be discussed in the next session. Thank you.